Remember, this is a guilty plea. Amanda Mitchell pled guilty to distribution of drugs, and then the issue comes down to what level of sentencing is she facing. So during her guilty plea allocution, the judge says, the prosecutor in federal court, it's always the U.S. attorney that asks the questions of you. Everything is tightly, those of you who do state court work, federal court work is much different. Whereas a defendant will get up in a state court and say, listen, I did this, I did that. Sometimes their attorney will question them. In a federal prosecution, the U.S. attorney types out the questions in advance. The questions are given to you. You go over them, you approve them, so that you're all on the same page. So that the U.S. attorney gets out everything they believe they need. And each one of those questions is part of the plea bargain. If you don't agree to the questions, you negotiate in advance, and you have to reach an agreement. And they detail your involvement in the crime, so the U.S. attorney gets to prove all the elements, and in this case, the weight. And when the defendant, Amanda Mitchell, was asked by the U.S. attorney, did you distribute these drugs? And she said, well, some of it. And, well, that's enough to get you a guilty plea. If you distribute any amount of drugs, you're guilty of a federal offense of drug distribution. But then when she came back for sentencing, they had to have a hearing to determine the weight of the drugs. And as Bob's indicated, you know, in the drug world, I mean, who are you going to have as witnesses? You're going to have other drug dealers. You're going to have people who are addicted to drugs, people who don't want to be in a courtroom, who don't like cops, don't like prosecutors. They're not going to be cooperative. And
Sounds
they got
like the defense bar, Joe.
Right. That's exactly right. But she had the testimony against her was going weakly. But when the government finished its case, the judge said, counsel, and said, no, we rest. And he didn't put his client on the stand. Well, the judge found that all the allegations had been proved in part because her disinclination to testify, her refusal to get on the stand and testify, the judge said he could draw an adverse inference against her for failing to testify. And that adverse inference, as you always know, is that she didn't testify because she could not truthfully deny the allegations and the testimony that had come forth at the hearing. Well, of course, that raises one real core issue with a collateral consequence. Does she have the right, a Fifth Amendment right, to remain silent at a sentencing hearing? Because if she did, well, then you can't draw an adverse inference from somebody that is exercising a constitutional right. Obviously, at trial, she has the right to remain silent. And the government's position was, well, she didn't remain silent. She put through a guilty plea. We asked her questions, and she testified about what she did. And the U.S. Supreme Court ruled differently than did the Third Circuit Court of Appeals, and found the following. They said, look, there's a marked difference between giving testimony at a guilty plea, that is, allocuting to it at a guilty plea, saying, listen, I did it, I was there that day, I touched the child, I distributed the drugs, I stole the money, whatever it may be. It's not as much testimony as it is sort of a stipulation. The state understands you're going to say you're guilty. You're going to say you're guilty. Your credibility is not in play when you are pleading guilty. You say you did it. Everyone in the courtroom accepts that that's the case. The right to remain silent is a constitutional right. Now, if she had taken the stand during the trial and testified, and they said, and on her direct, she said, look, yeah, I was involved in the drug trade, but, they found, 12 kilos of cocaine. I'm only responsible for some of it. I only distributed a very small part. I didn't know about the rest of it. The court said, it's clear that you cannot take the stand and testify on direct and then invoke the Fifth Amendment to protect yourself from cross-examination. Had she taken the stand and said, look, I only distributed some of these, wouldn't the U.S. attorney be allowed to cross-examine her in order to show that she had distributed a whole lot more, that she wasn't being credible? Of course they would, because the words that she said would come into sharp focus. But that's different. As the Supreme Court noted, in indictments which are not just dismissed, over 90% of the defendants plead guilty. So a guilty plea is by far the norm in federal court, just as it is in state court, and not trials. And so they said for most defendants, the only time the the privilege against self-incrimination is important is during the sentencing procedure. They go into this knowing that they're likely going to plead guilty. This is when they intend to invoke that right. There is nothing in their plea allocution, which is highly scripted and not subject to credibility determinations, that would say that they have, quote, spoken on the subject and thus waived the right to self-incrimination.